present will rise and judge the Circuit Court of Doddridge County. Oyez, oyez, oyez. Silence is now commanded under the pain and fine of imprisonment while the Honorable Judge Sweeney is sitting. All persons having motions to make, pleadings to enter, or actions to prosecute shall come forward, and they shall be heard. God save the state of West Virginia and this honorable court.
Thank you. Please be seated.
Your Honor, I'll go find David. I don't know where he is.
Okay. Party's ready?
Yes, Your Honor.
All right. That comes on for hearing the matter of EQT Production Company versus the Doddridge County Commission, case number 12C17. And the plaintiff in this case appears by David Henderson and Steve Hastings. And the defendant in this case appears by Mr. Tennant. The interveners, Joy Huff, trustee for Randy Huff. Decedent's trust B and William Lee Huff. Appears by David T. Richardson, and the Fosters appear by their counsel Bradley W. Stevens. This matter comes on for hearing today on several matters, and I think what we're going to do is, as a preliminary matter, take up potentially dispositive motions, beginning with the interveners' Huff's motion for summary judgment. Mr. Richardson, if you'd like to address that, you may proceed.
Good morning, Your Honor. David Richardson, appearing on behalf of Huffs, Joy Huff, and William Huff. Arguing my motion for summary judgment based on the fact that the floodplain permit issue was issued by an individual who, pursuant to the floodplain ordinance, lacked the authority to issue said permit. The ordinance itself specifically designates which person shall be the floodplain administrator, and does so repeatedly. It indicates that the director of the Office of Emergency Services shall be the floodplain administrator. Commissioner Terry Evans, at the time he was signing permits as the floodplain manager, was not a director of the Office of Emergency Services, and dominated rolling nicely across. There is case law in the Virginia Supreme Court, Harrison v. Town of Eleanor, which holds that building permits issued in violation of the building ordinance are void as a matter of law and confer no rights to the permittee. So here we have a permit that's issued by a guy who had no authority to issue it. Therefore, it violates the Doddridge County floodplain ordinance. You can't, under the ordinance, have a valid floodplain permit unless it's issued by the actual floodplain administrator. So as a matter of law, this permit is void. If you take that and then you apply it to the due process, both substantive and procedural aspects of petitioner's case, well, you don't have a due process right unless you have a legitimate property interest. And if you have a void permit that confers no rights, well, you have no legitimate right. You have no right to due process because you have nothing. And then going right along to the Open Government Procedure Act, or Open Governmental Proceedings Act, it has a limiting factor in terms of who can bring that action. It specifically states only citizens of the state of West Virginia. Now, EQT in their response concedes that they are not a citizen of West Virginia. There is case law in the Fourth Circuit that holds that the citizens only access provision of a law like that as in Virginia is constitutional. Admittedly, certiorari have been granted to the Supreme Court, but right now, that's the law. And logically, you can't have a Commerce Clause violation. We can't have a privilege and immunity violation because EQT is a corporation. You can't have a Commerce Clause because a law like the Open Government Proceedings Act, it doesn't affect commerce. It's just about keeping public officials accountable and allowing the citizens who are wronged by their behind-the-scenes activities to bring it to the court's attention, get the thing overturned. It's not about putting a tax on something or saying you can't hire certain people or your truck comes through here, it's going to cost you. EQT responds by conceding that Harrison v. County, Illinois, is generally the rule, but they're seeking to carve out an exception with the de facto officer rule. And they say that because Jerry Evans was acting under the color of the authority of the floodplain administrator, and they relied on it. Therefore, it's good because the actions of the de facto officer can't affect a third party. Well, Harrison v. Town of Eleanor doesn't carve out an exception. It's very clear. If it's a building permit, issued in violation of the building permit, it's void. And furthermore, I haven't seen any cases of the de facto thing. I've only had it a couple days. I don't see anywhere it's a building ordinance. All the cases I've come across are the person is an individual who was wronged, who was wrongly terminated, or deprived of something. It's not a third party who's being affected by something, potentially public safety issue. And then because of this technicality, the government of a guy who shouldn't be doing the job, issuing a permit, these other people are now affected. It's not like Jerry Evans hired me, but he didn't take an oath, and therefore technically he's not the floodplain. He's not the floodplain administrator, only the director of the Office of Emergency, and there's a reason for that, because flooding is an emergency. They want the person who is going to be dealing with the after effects of the flood, who knows about it, who can then take the steps to make sure that it doesn't happen beforehand. They don't want some random person just taking the job and then getting a permit and signing off blindly. They want someone who understands the implications. If you look at Chapter 15 of the West Virginia Code, what it defines an emergency, flooding is one of them. Chapter 15, Homeland Security emergency, it just got amended so that now it's mandatory that the floodplain administrator gets trained. I mean, there's a correlation. There's a reason for that. Furthermore, EQT, they lay out the de facto official rule is quite complicated. There's 4 different ones. In EQT's version of this, they combine the first one and the second one. So the first one starts off, you have to be acting without election, without known appointment. And then you have circumstances or reputation that are calculated to induce people to do something. And without making them feel like they need to ask questions. Why are you asking me to do this? Why do you want money from me? And that results in them supposing the person is actually the officer that he claims to be. That's the first one. The second one is under the color that the guy has a known and valid appointment or election. Not to pick on Jerry Evans, he gets elected commissioner. Everybody knows it. But there's something where the office failed to conform to a precedent or condition. Say Jerry Evans was 32 and he needed to be 35. Well, what EQT does in their rule is they take the known from the second rule, and then they put it in front of the first rule. So they effectively made their own rule about the fact they're a public official. I wish I could make my own rules when I'm arguing. And furthermore, they skip the whole beginning. It's not just like this automatic inquiry and then boom, okay. There's considerations that the court has to take. The lead-in is the law upon principles of policy and justice. EQT doesn't address that other than maybe just a set it. It doesn't apply to the facts. When it gets down to the actual applying the hybrid rule to the facts of this case, they're just conclusory statements. They don't say how Jerry Evans induced them to submit or invoke his actions. They say a sentence. Jerry Evans induced us to submit and or invoke to his actions. There's no facts there. Because if you look at the deposition of Jerry Evans, what he tells them is, y'all, I don't know. Call Kevin Sneed. How is he, under the color of the law, inducing them to do anything when he tells them, I don't know, call Kevin Sneed? It's one of the mandatory elements. He's got to get them to do something. Submit or invoke his action. I mean, the way it's phrased, it's almost like somebody taking advantage of the situation that people think, he's a tax collector. There's no election, there's no appointment, but he goes around telling people that he's a tax collector. And you need to give me some money. And I'm a tax collector. So people give him money because he's convinced them he's a tax collector. Jerry doesn't do anything. Just, I don't know. Hard to see. I mean, it's a complicated rule. It's about, that. But if you look real close, you can see where they just kind of mix and match. They just make up their own. That's inappropriate. And especially given the gravity of what we're talking about. We're talking about people's potentially lives. This is flooding. They're going to maybe make it out to be that this is about mining your property. It's not. It's about flooding. It's about a community where the vast majority of the people, the residents, are elderly. You expect them to swim? There are thoughts of justice and policy that need to be taken into consideration as you go through the elements. I mean, it's what you need to do first. And then when you get to their argument against the Open Government Proceedings Act, they basically concede it to a certain extent. They do argue against it, but they have no authority. Meanwhile, I've cited cases that have said it's fine. And then the alternative that they offer is if it's not fine, then please let Mr. Bowman, our employee, take our spot because he's a West Virginia citizen. I don't know of any case law. They didn't cite any case law. That's like the health department shutting down McDonald's and then the cashier takes the spot of the McDonald's. It doesn't make sense to me. He has no vested interest. He has no legitimate property. He's not in the case. He was never in the case. So for him to take the place just so they can keep this thing going, that they have no right to keep going under the law, under the strict restriction as to who can bring it, I believe it's inappropriate as well. If possible, I'd like to reserve some time to respond to Mr. Hastings or Mr. Henry.
All right. Thank you, Mr. Richardson. Mason.
Thank you, Your Honor. Despite what Mr. Richardson says, this is not a complicated issue, it's a simple issue. And in considering motion for summary judgment, the court's clearly well aware of the standard, and you have to give the benefit of everything, benefit of the doubt of everything we say, and construe those facts in the light most favorable to us. Now, we are in a little bit different situation because we're not going before a jury. The course, we'll hear all this. And so I will respond to each one. I just want to point out that what the standard is. Mr. Evans was not a tax collector out there just trying to cut people's money. I understand flooding is a serious issue. But the reality of it is Mr. Evans was a floodplain manager. We applied for and obtained the permit in November 2011. If you will look at, and we put all this in our responsibility on, but I'm going to go to the record here. If you look at the affidavit of Shirley Williams, she's the president of the county commission. Mr. Evans was actually appointed by the county commission in 2010 to be the floodplain manager. Now, I think that was January 2010. I don't have the exact date. He continued to act as a floodplain manager after the passage of the new ordinance. And what's interesting in this case, Your Honor, and it's an interesting dynamic that really hasn't come out between the parties, but there was an old ordinance. We'll call it the old ordinance and the new ordinance. The old ordinance was a 91 ordinance. The new ordinance was 2011. Our surveying agent, Mr. Smith Land Survey, will come to testify today and say that his office contacted the county commission in 2010. The year before this, in December 2010, they're telling us they don't even think we need a floodplain permit because our operations are temporary. Nothing changed in the new ordinance to the old ordinance to really change the effect of whether we really need a floodplain permit for this development. But my client, being above board, went ahead and went through it. EQT was the first company in West Virginia to apply for a floodplain permit for the drilling gas well, West County. So who do we go to for this floodplain permit? County Commission. Who do we call? Clerk's office. Clerk's office says, talk to Jerry Evans, he's a floodplain manager. So that happened in 2010. We started doing some work, we did the floodplain study, all of that takes place, and then in the meantime, the new ordinance is passed. And calls back, we're told to call Jerry Evans. This was in November 2011, after the new ordinance was in place. We contacted the county commission said, call Jerry Evans. Now, Jerry Evans, with all due respect, may not know everything that goes into what's necessary for a floodplain permit. We're here today because there were some missteps along the way. There's no question about that. We can talk about due process all day long here, Judge. There's no question our client's due process rights have been violated over and over and over. Jerry Evans says, let me check. I'm going to direct you to the state. Kevin Sneed, who's going to come here today and testify to the extent the court wants to hear that testimony. He's the technical advisor for Doddridge County. He's the state coordinator for FEMA. He coordinates with the national representatives. In the entire state, if anybody knows about floodplain ordinances and what you need to do, it's Kevin Sneed. Kevin Sneed provided us with the application process, told us to turn into Beth Rogers, the county clerk at the time. We do that, and Jerry Evans signed it. He was in fact appointed as a floodplain manager. Shirley Williams admits as much. And to the extent that he's not, there's a question of fact of whether he needs a de facto floodplain manager, de facto appointment. It was the acting authority. And it's even confirmed after this issuance of the floodplain permit in April, the letter rescinding our floodplain permit came from Jerry Evans, the floodplain manager. The county commission, in the open meeting, which we'll get into later, we didn't have notice of, rescinded it. They all acquiesced that he was a floodplain manager and told him directly to do that. They accepted his resignation in May and appointed another one, again not Mr. Nicely, the OES director, or anybody else. They appointed Dan Wellings. The county commission was acting as if he was a floodplain manager. It wasn't some guy off the street. He is actually a county commissioner who enacted the statute, was acting as a floodplain manager. He was trained by Kevin Sneed through the state. He testified when we took his deposition this summer that he received 30-some odd hours or something in training. It's not like he doesn't know anything. So I think with the specific issue of whether we have a lawful permit in the first place, John, where else are we supposed to go? What else are we supposed to do? If we can't call the county clerk up and say, what do I got to do to get this permit? They don't steer us in the right direction. What else are we supposed to do? it doesn't void, it's not void because it's unlawful. And the court needs to be mindful of its jurisdictional authority in this case that we're having here today. We have injunction authority to enforce the provisions of the ordinance. If Mr. Richardson and his clients have their way with respect to this issue, here's what happens. You throw this case out. We go back and apply for the floodplain permit. They're going to deny us, Your Honor. It doesn't matter what we tell the county commission, they're going to deny the floodplain permit. We come back here another year. He was the floodplain manager. They ratified his decisions, acquiesced in his decisions, and a question of fact exists as to all that issue. So therefore, their motion should be denied. Mr. Richardson was talking about policy and justice and what we don't mention or do mention. Your Honor, it should be clear to everybody in this room that development is allowed in the floodplain. There are people in this case that act as if there can be nothing in a floodplain. If there can be nothing in a floodplain, the floodplain ordinance wouldn't exist. It would just be a simple one line. You cannot develop in a floodplain, period. We comply with the ordinance, we should get floodplain permit. The policy dictates that. The stated public policy of the state of West Virginia is the extraction of minerals. We can go all day with that kind of stuff. I'm not going to belabor it. Now, regarding the Open Government Proceedings Act, Mr. Richardson brings up a couple of things, and I'll be the first to say, Your Honor, I'm not a citizen. However, it should be noted that the county commission didn't move for summary judgment on that issue. They didn't do it. You guys, Courtney's asked that why. I'm not sure the Huffs have standing to even make the argument. While the court ruled that they had a property interest in the development on their property, they have no property interest in what we're bringing against the county. So I'm not sure they have standing to bring the claim. That's the first step. Second step, Mr. Richardson cited a law applying the Virginia law. It says it's a law of land. Your Honor, with all due respect to Mr. Richardson, West Virginia is a separate state than Virginia. And while the court would look at that, to look at reasoning and considering it, it has to be a violation of interstate commerce because of this. We have a property interest in all minerals under that grant and a right to explore those minerals. The Open Government Proceedings Act is meant to protect people, public, companies, everybody that might be affected by what that board might do. If there's ever a reason why there needs to be an Open Government Proceeding Act, Your Honor, it's this case. Because what did they do? They revoked something that we had. They took action at that meeting. And again, Mr. Richardson, I didn't make interstate commerce, Your Honor. We all learned that in law school. It's been a while since I've been in law school, and you don't think much about it. But since Mr. Richardson brought it up, it is a violation of interstate commerce that only citizens can bring it. Because if this county commission is going to take actions that affect citizens like that, of other states, that have rights in West Virginia, then they need to be noticed of it. Now, I understand what Mr. Richardson's argument is on quote-unquote citizen needs to bring the action. The language speaks for itself. Your Honor, but this is not a case for strict statutory construction on that issue because it's unconstitutional because it violates the Commerce Clause. It's unconstitutional because it violates our due process. And again, what we're talking about in this case is an injunction. Today, in this case, we're talking about an injunction. The court can consider it. It absolutely goes to unclean hands of the county commission. And quite frankly, Your Honor, to the extent it gets necessary, there were misrepresentations made by at least one of the interveners directly to the county commission, which resulted in rescission of the floodplain permit. So the court can consider all of that. If the court requires us to strictly comply with that, parties are substituting out cases all the time for third party interest. Sometimes it's done by stipulation. And Mr. Bowman is a citizen of the state of West Virginia. And we would ask that the court, to satisfy the court on the issue, that he be substituted in. We don't think it's necessary. We don't think the court should allow this kind of activity to take place without repercussion, Your Honor. It was something that the county commission did. This particular county commission has done it over and over on their meetings. There are concerns of people in this room that I know of that specifically brought to my attention that they're continuing doing it. And with all due respect to citizen other issues, I'm here on this issue for my client. So I can't do anything about that.
Just so I can understand your point on that, are you saying that you think the Open Governmental Proceedings Act is unconstitutional because it unfairly discriminates against your client, inasmuch as your client is not technically a citizen nor a resident of the state of West Virginia?
Yes.
Okay, I just want to make sure I understood your argument, so. Point of clarification.
Just that limited aspect of the statute, Your Honor. Because otherwise, I mean, how can we come and protect our rights? I mean, Mr. Sneed, in this particular scenario, Kevin Sneed with the state contacted the county commission and said, you need to stop this floodplain development because we don't have certain information. That's clear stuff. Well, had they put it on notice, and then, we see the notices that come out, they're published, we could come and intervene at the time and say, wait a minute, we're going to hold on, but let me show you what we've done and all this other stuff. I mean, that's why that would be there, for people to come and speak. Mrs. Huff is not a citizen of the state of West Virginia, Your Honor. We fought this case of whether she's a citizen of California or Texas. I think it's Texas. But, she's not a citizen either. Mr. Foster, citizen of West Virginia.
Okay,
So,
I understand your argument.
all right, thank you, Your Honor.
I'm going to ask you, I think, because at least considerably in the intervener's amended motion for summary judgment, the issue of constitutionality was raised, and I see that there's been a filing by the plaintiff in limine to exclude any arguments as to the constitutionality of the ordinance. So what I'm going to ask you to do, if you don't mind, I hate to pull you up from your agenda into this particular position in the proceedings, but I think it might be appropriate to go ahead and address that now, and then we'll permit Mr. Richardson a chance to respond.
Yeah, Your Honor, just for the record, it doesn't matter where we go on the agenda, it's just listed everything. The reason why the constitutionality of the floodplain ordinance shouldn't be an issue in this case is because there's a provision in that particular statute, the ordinance, that anybody doesn't like, they can get that changed. Now, arguably, people sit there and say, well, you go get the citizen aspect changed, but that's just recently in motion for summary judgment. They could have brought the case, and I believe originally brought the claim in this case against the constitutionality of the floodplain ordinance. And the issues then are now not pending in the case because they didn't bring them in the actual answer to the operative complaint. The only claims in this case are our clients, EQTs. The Huffs intervened to defend their position. They did not make a claim against EQT in this case. They did not make a claim against the Doddridge County Commission in this case. They could have.
Well, let me just correct that. They actually did, but they withdrew it.
Oh, no, okay. Thanks for the clarification. They withdrew that claim. And to the extent, and I think here's where I think they're going to go with the constitutionality of the Wise issue, and we can wait till it comes up, if it comes up at all today, Your Honor. Obviously, motion to eliminate is what we think will come up. We think that they may argue that they didn't have notice of our floodplain permit, therefore they didn't have appropriate time to object to it, to appeal the decision. I think that's what we're talking about in our motion. And so, something else, I'm not aware of it, we're just moving to eliminate, and we're happy to reserve the right for everything else once testimony comes in, except this issue. The provision, the ordinance does not provide for any publishing or notifying the public of issues of floodplain permit. I get that. That doesn't matter in this case. And the discovery response is filed this week by Joy Huff. They knew on March 16th that we had a floodplain permit. Now I have evidence to suggest they knew earlier, but I'll go with their date. March 16th. Once they know about an action of the floodplain management, they have 30 days under the ordinance to appeal it. The county commission meeting was April 17th. That was an appeal. They've never appealed it. So because they didn't appeal when they knew about it, to the extent it's unconstitutional because it wasn't posted, it's irrelevant. It's waived. They knew about it. They had 30 days and didn't do it. So now whether it's constitutional or unconstitutional, you can't sit on your right, Your Honor, and complain about it later. So that's the crux of that argument. If there's any other constitutional arguments, Your Honor, that they plan on offering, I'm not aware of, and we can address those. But that's the crux of that position.